This is WPSL Port St. Lucie, the talk of the Treasure Coast.
The opinions on this program are those of the program host and guest and not necessarily those of WPSL. WPSL does not endorse products that may be mentioned. Any reproduction or retransmission of this broadcast is strictly prohibited without written consent of WPSL. Legal questions? Ask a lawyer. Give us a call at 340-1590, 340-1590 here at the studios of WPSL. And Ask a Lawyer with your host, attorney Stuart M. Address.
Good morning. This is Stuart Address for Ask a Lawyer. And I say hello to you listening far and wide, especially those of you in Ukraine.
Serbia.
If you have a server, please send it to me. And President Zelensky.
With 2016
Right.
election results.
President Zelensky, if you're listening, I'm willing to offer you a visit to my office. I'll even do some reconstruction and make an oval if you'd like.
Free bagels.
Free bagels. Hey. What
Maybe
more
some
can you
locks.
ask? What more can you ask? All right, so barely hearing through the headsets, but that's okay. I don't know. Anyway, so yesterday was an interesting day. Yesterday, my office, we had a press conference announcing the filing of a lawsuit, whistleblower action against St. James Christian Academy, which is a K-12 school and the largest preschool in St. Lucie County. Now, folks, I can't promise you that every case gets a press conference. I tend to do maybe one or two a year. But sometimes certain cases seem a bit newsworthy and have the sex appeal that might attract some television cameras.
Whistleblower. I've heard that terminology somewhere.
You know, we discussed, they didn't show that, of course, on the edited version of the news, but we discussed the whistleblower issue. Yesterday, the NBC reporter asked me whether or not it's fair to consider a whistleblower as a disgruntled former employee. And I said, well, you know, if the whistleblower is complaining about one item and has never complained, you know, before while employed, perhaps. But, you know, where a whistleblower is complaining about something they've complained about over and over again, or where the whistleblower is complaining about multiple items that they've complained about, you know, frequently, then, you know, that's not a fair characterization. And I did make a comparison to the whistleblower in the impeachment hearings. And I said, you know, while that whistleblower under federal statutes, the identity is protected, so they remain anonymous, the hearings have borne out all of the facts contained in the whistleblower complaint. So whistleblowers are called whistleblowers for a reason, and very often what you're getting from them is very important truth. Although I will admit sometimes you do have disgruntled former employees. And I made the point to those who were at the conference yesterday that although federal statute, for good reasons, protects the identity of the whistleblower, Florida statute under the Whistleblower Act does not protect your identity. And so our whistleblower was there at the press conference, ready to answer questions and be interviewed, and he was. And so there's no smoke and mirrors here. He was there for everybody to see.
Well, and they'll eventually find the whistleblower in D.C. I mean, there are no secrets in D.C. Come on.
For the longest time, the secret of who was Deep Throat. I'm not talking about the X-rated movie, folks.
You know, that was a whole different time in news. No, seriously. That was a whole different time in news. And, yeah, I can imagine. But
right.
Today, no. There are too many leaks in D.C. There are just too many. Somebody.
There are two. This is just a see Dick and Jane type of reference, but there are too many dicks in D.C.
Yeah, well, ooh. Do I need to
put
the delay?
You got former Richard Gephardt.
That's right.
And Richard Lugar. You know, there's lots of dicks.
You know, the problem with DC, too, is that all these guys, like you mentioned, they're all lobbyists now.
Yes.
I mean, God, and actually, who's the senator from Massachusetts?
Warren?
That's running. Yeah. I mean, she's got a good idea. A lifetime ban for a legislator becoming a lobbyist. I love that.
I do think that has some merit. I don't think you should necessarily be able to profit off of your government public service and go into a cushy lobbying job.
Yeah.
I think right now, unless I'm mistaken, there is a 5-year restriction on lobbying. I may be wrong on that. Maybe there should be a longer restriction, or maybe there should be a lifetime restriction. If you're not supposed to benefit from being in office while in office, and that applies to the president, and that applies to members of Congress, and that applies to any government official, then I don't know that you should actually be able to benefit from having been in office, except for natural progressions of, getting a nice law firm job, or running for another office.
Well, that happens all the time in D.C.
Yeah, but being able to go back to your fellow legislators and lobby them, I don't know that that's such a kosher idea. We can ask the rabbi later on if it's kosher.
Yeah. Nice seeing you, by the way, at the Treasure Coast Expo.
That's right. I saw.
Love your popcorn.
Thank you.
Man, I love that.
I saw WPSL there.
Yeah.
And yes, for the temple I was there, and for my firm I was there popping popcorn. I order a very special mixture, and I think it tastes just like movie theater popcorn.
Boy,
it's
did.
Wonderful.
It did.
Very tasty.
Or baseball park
and
popcorn.
I have to give a shout out to my girlfriend who made some brownies with sugar on top. And boy, people were talking about how delicious those brownies were.
Yeah, I didn't touch those, but I hit the popcorn.
And the brownies had nothing funny in them.
Oh, well, that's why I didn't touch them.
Anyway, we have John on line 1. Hey, John, how you doing?
Hey, good morning. How are you?
I'm doing all right.
I had a question. I don't know if you've ever had this experience, and if it's not in your purview, then that's fine. But I've seen a doctor for a few years now, so I've known him. And last year he kind of did something that upset me. I only got to see him for a few minutes, but he charged me for more. And then this year was even worse. I mean, he made me wait an hour and 15 minutes. Comes in for 4
I
minutes
hate
and
that. I
charges
hate
me.
that.
Well, that's not so bad. It's just the fact that he spent 4 minutes with me and charged me for 25 minutes. Now, what does this have to do with me? It has to do with my copay goes way up when they charge a larger office visit.
Right.
What can be done with something like that?
Okay. There are regulations. I'm not familiar, but I know on the coding sheet that sometimes they give you as a receipt. There's a low-level office visit, an intermediate office visit, a high-level office visit, and they all have characteristics that apply to them. If there is miscoding, and that happens quite frequently, sometimes innocently and sometimes not so innocently, then that's an issue of fraud. It's also an issue of breach of contract. And the only way to really deal with that, I would think, would be a class action, because no individual subscriber is going to want to spend the dollars necessary to challenge something like that. I've long thought myself that when a doctor schedules you and makes you wait an hour and a half, that there has to be a breach of an implied contract there. I understand doctors are busy people, but when they schedule 5 people for the same time, figuring maybe 2 won't show up, I have a problem with that, because my time is valuable too. And if I kept a client waiting an hour and a half in my reception area, they wouldn't be there when I opened my door to see them. And nobody would wait. Doctor, you're sort of, you're hostage, especially if you need them. So I've learned that's been a bone to pick. I've often had with doctors' offices.
But to have a class action suit, you'd have to know other people that are experiencing the same problem.
No. One person can go to a lawyer, and if it's a proper type of action for a class action, you file in the name of the person that came, let's say your name, and on behalf of all others similarly situated. And then you petition the court for the type of notices that you'll be allowed to deliver, and to whom you'll be allowed to deliver them, and how you'll get the information, for example, from the insurance company, of other people who might be similarly situated.
Mm-hmm. Yeah, I specifically told him not to bill me like he did last year, and I didn't get a very good response from him. I guess he got offended. And the problem is there's really, if you call your own insurance company and you make them aware of it, they basically do nothing. I have a very large, the top 3 insurance companies in America. I have one of those. And there's really nothing they do for you. You specifically tell them, you give them all the evidence, all the records, and they still say, well, all we can do is call the doctor, and if they say it is, then it is.
I know, and the only other recourse you have is legal recourse.
But not even the state gets involved in that. I mean, if you call state agencies, that you would think.
That's at their discretion. Unfortunately, that's at their discretion.
Yeah.
I would think they should be more interested in something like that, not just necessarily one person, being overcharged, but I would suspect, and I agree, it's probably a pattern, and it's an issue that some legislator probably somewhere should attack.
May I ask you another question
Sure.
on a different matter? Exception to orders of power. Now, I'm not an attorney, but I've done a lot of reading over the years, and if a condominium document says one thing and the Florida statute says another, my understanding is that if your condo docs are more restrictive than the Florida statute, you go by the one that's more restrictive.
No. Florida statute is going to supersede any condo doc unless, within the statute, it gives leeway for associations, to do a range of things. But if there is a conflict between a statute and anybody else's practice or policy, the statute's going to prevail.
Yeah, because I just found out in the Florida statute the bar is pretty low for amending a condominium bylaws. Apparently, all it is a majority of a duly held member of the membership, which to me is ridiculous because our quorum is only a third. So that means that basically we have 300 units, so basically 50 people can decide for the other 250.
Right. Well, unfortunately, if that's what the statute permits, if defining a quorum, and then the bylaws say whether it's a quorum of all owners or of those, present, and you have to look at bylaws, you have to look at the Declaration of Covenants, and you've got to look at the statute all together to come up with an answer.
Okay. Thank you.
Thank you for calling, John.
And what was very interesting in what John said, coding has become a major thing. And obviously IRSC, having, worked on a startup talk show, we brought in the coding instructors there. The one big thing Obamacare did do, believe it or not, is update the U.S. coding system to where it's now, I think they call it a 10. Europe is still like a 12 or 14. We're still in the dark ages when it comes to coding, but it's getting more professional now. It used to be wives and girlfriends.
There are coding agencies.
Yes.
And there are good ones and there are bad ones.
Yes, that's true.
Okay. I happen to know, I'm not going to mention names, but, a medical practice that had some significant coding problems, and one partner didn't like the way the other partner would routinely code.
Oh, boy.
And they ended up having to make repayments back to Medicare for Medicare reimbursements once they did an audit of the coding practices.
Sure.
And that creates liability not only for the doctor who engaged in the coding that was a little bit too liberal, but it causes liability for the other doctor who is an owner of the practice, and it could theoretically put that doctor's license at jeopardy. So these are very serious things. Medicare takes it very seriously.
Oh, yeah.
If they catch you, you're going to hurt a lot worse than if you self-report and pay back the money that was paid to you plus interest.
Yeah, I'll bet. And getting back to the waiting, I mean, I had an incident, my cardiologist, where I was waiting for, maybe 40 minutes. And then the nurse came out and said, look, there's been an emergency in the heart unit, and he's stuck down there. So I, get up and leave, and reschedule.
That happens.
Yeah.
But, and there are some doctors, I have some of them that routinely see you within 5, 10, 15 minutes.
Oh, most of mine
your
are.
appointment time.
Yeah.
But then there are those that you wait in the lobby, then you wait in the interior room, and, it's an hour and a half later until you see somebody.
Oh, that's horrible.
And I can understand John's frustration. If you wait that long and then you get a 2 to 4 minute, appearance with the doctor, you leave frustrated, where you heard. It's a little bit different if you wait that long and then you spend 20 minutes with the doctor. At least you go out thinking, they've heard me, they understand, and whatever has come of it, hopefully will help me.
He or she cares, yeah.
Yeah. I mean, I recently had a doctor's visit. It was less than 90 seconds, and
a drive-through.
I really did not get any sense of comfort that what was done, was really the likely correct course of action.
Oh gosh, yeah.
But that's the way it happens, and all you can do is be an advocate for yourself and stand up for it, and sometimes make a little bit of noise like we made yesterday.
Mm-hmm. Yeah. Well, that's
and
the squeaky wheel.
Yeah,
I mean, it does work.
I won't recount here now because we have other things to talk about. More details of yesterday's press conference, but I will tell you that you can find an article on TC Palm,
mm-hmm.
and if you want to go into the news archives of NBC in West Palm,
WPTV's got it.
At 5 o'clock and 6 o'clock they had something on us, and Fox had something at 11 o'clock.
Which is their sister station,
That's right.
Yeah, as we are.
And on my law firm Facebook page, I have posted each of the excerpts from the news broadcasts, and I have posted my little 20-minute presentation that I had my paralegal Sadia tape for me, since I knew that I'd probably only get a sentence on air. So if you want to hear more of my comments about what this lawsuit is about, you can go there.
Give me your best 10 seconds, baby.
My best 10 seconds.
That's, I remember when Carol was in Boston at WBZ, the news director came up with some harebrained thing. Maximum story length at 11 o'clock is 45 seconds. And it's like your soundbite's going to be maybe 8 to 10 seconds.
Well, you've got to do this understanding the concept of soundbite.
Yeah.
You have to have sound bites ready.
Oh, yeah.
Hoping that they're the ones that will be utilized. And sometimes they are and sometimes they're not.
Yeah, well, that's true. That's true. Having done it for a long time,
when I talked yesterday about how 2 young ladies who were kissing on a school bus were handled and called it an abomination, I thought that was a pretty good, line that might make it, but it didn't. So if you want to hear it, you'll have to go to the Facebook site of my law firm and find it.
What is that site, by the way?
It's Law Offices of Stuart M. Address. Google it, and you'll find it on Facebook.
Cool.
Or if you go into Facebook and do it in the search bar, you'll find it. Like it and see what else we post. Pretty soon I'll probably transition, my Facebook Live from my personal site to the law firm site, which makes a lot more sense.
Good idea. Yep.
I dual post it, but it probably belongs there.
Yeah, our engineer is wrestling with whether we're going to go Facebook Live in this place or whether we're going to keep going with not just YouTube on demand, but YouTube Live.
Yes.
So he'll figure that out.
And I see an article. I see a comment now on Facebook Live from my favorite Yenta that there's an article in today's newspaper as well.
Mm-hmm.
So,
a what?
An article in today's newspaper.
A newspaper. I think I saw one in a museum.
Those are those things that they make your hands dirty if you hold them for too long.
Yeah, that's it. Yeah.
Yeah. They're really big ones. It's very hard to fold, and it's like holding a slice of pizza. It droops and everything. I mean, a good slice of pizza, a New York slice of pizza, with the oil running down your wrist.
Yeah, there you go.
The newsprint just comes on everywhere.
All the news that's fit to drip.
That's right. All right, so last week we talked about impeachment, and I think I talked about it for the most part in a nonpartisan manner.
You did.
Trying to focus on what are the reasons for impeachment if you believe, as is likely, that there will be no conviction in the Senate. And what are reasons for impeachment that are a waste of time if you know that there will be no conviction in the Senate. and what may be reasons for impeachment that are perfectly legitimate and even part of our democratic principles, even if you know there will be no conviction in the Senate. And they were two very different sets of concepts that have been spoken about by, legal historians, legal biographers, legal philosophers. And it boiled down to essentially, if your goal in seeking impeachment is merely to get rid of the office holder, and you know that is not going to happen, then it is likely a waste of time going through with an impeachment proceeding. And I know that a lot of people will start screaming, yelling, that's what's going on right now. Well, a little partisan part of me says, no, it's not. But if your reasons for impeachment have to do more with setting a standard, having the House say, this far and no further, or this is what we deem to be acceptable or unacceptable conduct of a president, those reasons for impeachment are valid, even if there's no conviction in the Senate. Because those reasons for impeachment will stand the test of history and can always be looked back at as this was a problem, and here is the way it was viewed, and they can debate pro or con, for the next 100, 200 years, but it sets a mark and it sets a standard that might not otherwise be there, even if the office holder is not removed. So let's assume, as I think is fairly safe, that by Christmas, President Donald J. Trump, the 45th President of the United States of America, will be impeached. What happens? What happens? We all know there's a trial in the Senate. What's a trial? Is it like the trial I have in St. Lucie County in front of a jury? What's the trial? Well, let's talk about that because it's not clear.
Yeah, what is a trial?
The Constitution does not specify the requirements for a trial by the Senate in an impeachment proceeding.
Who's the judge?
The judge is the Chief Justice of the Supreme Court of the United States.
Whoa.
Yes.
He comes to the Senate?
He or she,
yeah.
And it could be a designee, I believe, if the Chief Justice designates somebody else. But in the Clinton impeachment, it was the Chief Justice. I don't know who it was in Andrew Johnson's days.
I don't think you were quite around yet.
No. But presumably it would be the Chief Justice.
Okay, wow.
And the Chief Justice sits, get this, folks, as a trial judge. Now, remember that the Supreme Court of the United States is the highest appellate court in the land. What happens in the Supreme Court are not trials. They are appeal hearings. They are where two lawyers get up and argue what the lower court did was right or was wrong, and for these legal or evidentiary reasons, the Supreme Court should adhere or change the decision of a lower court. It's oral argument and perhaps sometimes nonstop questioning.
Isn't that basically what a trial is in front of a judge?
No, trials with witnesses being sworn under oath and cross-examined, and introduction of evidence. None of that occurs in an appellate hearing. None of that occurs before the Supreme Court.
So there are no judges in an appellate hearing?
Oh, yeah, they're usually
not judges, but
no witnesses. No, not at all. No.
Just you and
Just
the opposing lawyer.
The record of the lower court and you and the opposing lawyer's arguments as to what the lower court did right or wrong.
Wow. Okay.
And so, theoretically, if I were to have the privilege of arguing before the Supreme Court, I am a member of the Supreme Court bar, which was a lot of fun getting admitted to.
How long did that take?
I think it gives me a 10% discount in the gift shop.
Yes.
But it also gives me the right to sit and listen to a hearing from start to finish, whereas members of the public go in for 5 minutes at a time.
Oh, I didn't know that.
Yes.
I didn't even know the public was.
They get you in and out because it's a tourist stop. But if you're a member of the Supreme Court bar, you're allowed to go in there and stay.
Wow. Okay.
So, one day I would like to take advantage. I was hoping they would be in session when my son went to D.C. last year with the band, because then I was going to kidnap him from the band trip and take him to watch a Supreme Court hearing. But they weren't in session. So what really happens is if I had the privilege of one day having a case that made it to the Supreme Court, I would stand up, may it please the court, Mr. Chief Justice, Associate Justices, and I would launch into my presentation.
How long would that presentation be?
It depends upon what the court gives you. Typically, it's 30 minutes each side. But you don't get very far typically into your presentation. For example, what could happen would be, may it please the court, Mr. Address, and one of the justices already asking me a question.
Oh, God.
And then your 30 minutes can be taken up by 9 justices throwing questions at you like a machine gun, and you never get to say anything you wanted to say. You just answer their questions.
Does that happen?
All the time.
Really?
All the time.
Oh, okay.
You get a sentence, 2 sentences into your thing, and questions go on. They start. Same thing with your opposing counsel.
And there's no television cameras in there, right?
In the Supreme Court, no television cameras. But a lot of the hearings are available on audio.
So they're
Go to the Supreme Court site.
Oh.
There is audio.
Okay.
But they still believe that TV cameras are a distraction.
But news organizations can't use the audio in the Supreme Court, though. Is that correct?
I don't think they can.
Because I
don't think it's made available simultaneously.
Because I know the NBC courtroom artist who does all the Supreme Court stuff. Yeah.
So anyway, these are appellate courts. The judges, all 9 justices sit and throw questions at 2 attorneys. The justices have received tons of materials, are fully versed in the case, and their questions are often not designed for the answers that they're interested in. They're designed to get you to answer a question that maybe another justice is having trouble with, because they want to get that other justice's vote on their side. So they know the other justice is troubled by an issue. So they are asking questions leading you in a way that hopefully gets you to answer in a way that satisfies that other justice's concern.
So how would they know that justice has got concerns?
Because they sit and they have conferences every week.
Oh, they do?
And
okay.
They circulate draft opinions. And they have preliminary case memos that their law clerks prepare. And they talk. And you tend to know, even if you don't discuss a case, if you know the justice's judicial bent, you might know what issues are going to be problematic, and so you might try to get those dealt with. You're very confident about how you're going to vote, but you're trying to get that other 5th vote or 6th vote.
Right.
All right. So that was a little detour. So going back to the trial in the Senate, what we know from Article 1, Section 6 of the Constitution is the Senate tries all impeachments. We know that the Chief Justice is the designated judge for the trial. Article 1, Section 6 says, the Senate shall have the sole power to try all impeachments. When sitting for that purpose, they shall be on oath or affirmation. When the President of the United States is tried, the Chief Justice shall preside, and no person shall be convicted without the concurrence of 2/3 of the members present. So you have a 2/3 requirement, which is why it's fairly safe to say there will be no conviction of President Trump.
Do senators ever show up?
And they all show up for this.
Okay.
Trust me.
Is it mandatory?
No, but this doesn't happen very often in our history, and I don't think any senator that is of health is going to miss an impeachment trial. So that's what it says. Okay, so what's a trial? So, we've only had 2 of these in the history of this entire country. And we have to look back on that, and then we look back on what could be done, and we look at the Senate rules. We look at what the Senate was going to do in the Nixon era, because there's notes as to what the trial would have looked like. So what are the options? Well, one of the options is a vote with no discussion whatsoever. No discussion, no documents, no witnesses. If Mitch McConnell decides we are going to try the case and we are going to take it up on vote, unless there is some way the Democrats can block that, it's over in 30 seconds.
That's a kangaroo court, though.
It sounds like it, and that's probably why it won't happen. Because it has no credibility.
Exactly.
But it could be. Because there's no restriction in the Constitution to just taking the articles of impeachment that have been passed by the House and calling them for a vote. Now, what is there then for the Chief Justice to preside over? I guess the vote of the jury, which is the senators. That's about it. Another option is a full trial. A trial where both sides get to introduce witnesses, introduce evidence, have objections, where theoretically the president could come to testify if he was so inclined. I believe in the Clinton impeachment, Clinton testified by video.
No, Trump would want to be there.
And
it's reality TV.
It was done early at an earlier time. It wasn't like
sure.
live.
Yeah.
Well, if Trump wants to be there, that's pretty stupid in my view, because all he has to do is be cross-examined by, Senate counsel and some of the people, and the lies will start to explode, and he won't know which way to go, and his lawyer won't be able to help him. No, he will not show up. Not a chance. All right, and then what about an abbreviated trial? A trial by any other name. What are the rules? Well, the rules are fashioned by the Senate. If the Senate says, we're going to let you present all the witnesses you want, that's a lot more close to a full trial.
Why aren't the rules set by the Supreme Court? They're the ones that are judging
Constitution doesn't say it. And the Senate is the jury, so the Senate controls all impeachments, is what the Constitution says, Article 1, Section 6. So if the Senate votes, remember the Republicans right now control the Senate. If the Senate votes that each side can present 2 witnesses, and the witnesses shall testify for no longer than 15 minutes, that's the trial. So what we don't know right now is, and I'm going to use the word when, is when President Trump is impeached, and let's say in January the Senate takes up the trial, we don't know what it's going to look like. Because while the Republicans have caucused in private about this already, and in fact today they're meeting with the White House to discuss it.
Right, yeah, I read that.
We don't know yet what they are going to propose. We don't know what they're going to be able to pass as their determination as to how they're going to conduct their own rules. So we don't know what the Chief Justice has to preside over yet. All we know is that the Constitution requires a trial. It doesn't specify the kind of trial. And in cases of impeaching the president, the Chief Justice is the presiding officer.
Will our Chief Justice sit next to the Ukrainian Chief Justice? Oh.
And so these are interesting and unique situations where you have the Chief Justice of the Supreme Court sitting as a trial judge, ruling on objections in real time, as a trial judge would do. It happens almost never. In fact, there is another circumstance in which the Supreme Court can sit as a trial court. Very, very, very rarely utilized. And the Supreme Court has to agree to it.
Like the whole Supreme Court?
Yes.
Ooh, that would be cool.
If the United States is suing another country, or if another country is suing the United States, the Supreme Court can opt to hear that as a trial court instead of having it go through the federal court process.
Interesting.
Now, honestly, I've never really looked at it. I don't know if it's ever happened. But I do know that that is an element of what is called original jurisdiction, which is where they are the original court. They have the option of electing to take that case and handle it themselves.
But how long has it been for any of those justices to have been in a trial? That's got to be decades.
Probably.
Wow.
One would think it's like riding a bike, but you never know.
Yeah.
I'm pretty sure the best one at it would be Justice Ginsburg.
Oh, she'd be awesome.
She doesn't, she doesn't,
be awesome.
she doesn't forget anything.
Yeah. She would be great. Yeah.
All right, so let's look really quickly as one illustration before we leave the topic. In Clinton's situation, in Clinton's impeachment trial, the rules gave the senators a passive role. They sat as a jury. They did not get to question. They merely got to vote. There were rules as to witnesses that were being presented. They were handled by counsel that was prosecuting the impeachment and counsel that was defending the president, presumably whatever counsel the president wanted. And the senators sat quietly, which is an amazing thing, because they didn't have the right to speak. They only had the right to vote.
They have gags for these
Right.
guys?
They only had the right to vote. And that was a form of a modified trial that they had determined would be utilized during the most recent impeachment trial in our history, the only one in modern history. And we have Bob on line one. Hello, Bob. How can I help you?
Yeah, hi, Stuart. I realize this is ask a lawyer and not ask a politician, but the question I have, or the that I have, is sort of germane to what you're talking about. I was having a discussion with a friend of mine. I feel the same way that you do about Trump. She loves him. And I said to her that if Trump is impeached and not convicted in 2020, the Democrats can walk in, theoretically.
Can walk in, you mean would win, and is that what you're saying?
In other words, they'd win hands down.
That's a possibility. It could go the other way, unfortunately. It could give Trump more ammunition to argue this grand conspiracy against him and, get some of the independents. Because that's where that's where this election is going to be decided. It's going to be decided with the independents. And if they go with Trump in the numbers they did in 2016, seeking change, he'll be reelected. I gag on that, but he will. If, however, they don't continue to support him in those numbers, and it didn't take a lot of numbers in only a few states, then no, he won't be reelected. It's not clear how this impeachment will go if he is not convicted, and most likely he won't be. It could work for the Democrats. It could work against the Democrats.
Okay, I was just curious as to whether or not my theory was correct or not.
I hope it is. I hope that with more information, the American public, at least that pays attention, and I'm including most independents there who really have to decide how they're going to vote, will be swayed enough to believe that President Trump is a risk not only throughout the world, but to our actual democracy. I mean, in my view, although I don't believe he will be convicted, to allow the things that I believe are clear and beyond a reasonable doubt, including things he's admitted, on camera, to allow anybody to get away with that, strikes a dagger at our Constitution and the credibility that it has stood for over 200 years. Here and abroad.
Okay.
So I hope you're right, but I fear that you might be wrong.
Okay.
And I, too, have somebody I speak with frequently who is a Trumper. And,
Right.
there is no dissuading them.
What will this FISA announcement on December 9th do?
That's interesting. Look, if it finds wrongdoing in the initial warrants that allowed them to eavesdrop on two of the senior members of the Trump campaign, even if the wrongdoing is technical, and even if the FISA court would have granted the warrants without, the objective report that is being complained about, people will not parse it through that clearly.
No.
All they will know is that the ultimate decision was against, quote unquote, the Democrats, and I think that would be that would be a dagger. I mean, not a deadly dagger, but it certainly will hurt.
Because isn't that what kicked off this whole thing?
Well, it is
sort of.
It is in part. I mean, the FISA court, yes, is what kicked off the whole thing, but it wasn't just necessarily that dossier that kicked off the whole thing. If other evidence existed, which was proffered to the court, would have been sufficient, and that's what the Democrats say is true, then the warrants would have been issued anyway. And this was just an abundance of evidence, to offer. But if it would not have been issued without the Steele dossier, then that's a problem. It doesn't mean that any of this other stuff is not true. I mean, it doesn't mean that, there wasn't some collusion with Russia, if there was. It doesn't mean that Trump didn't ask the Ukraine president to announce an investigation into Biden in exchange for a White House visit and $400 million in withheld aid. It doesn't change any of that, but it may change perception. So, thank you very much, Bob.
Okay.
That's interesting. That is really, really interesting.
And all of this will be debated for the next 100, 200
Oh,
years.
yeah.
We have Rich on line 3. Hello, Rich. How can I help you?
Yes, I want to take your comment about what you were talking about earlier as far as the impeachment moving to the Senate.
Rich, your phone is really breaking up. Can you speak directly into it?
Especially if you're on Trump's side.
I am, and I'm sorry. I'm in the car. I'm on my way to a doctor's appointment. I'll try calling back. I'm sorry.
Well, that's okay.
So far, I can make you out. Go ahead, ask a question.
Okay. Mitch McConnell's made it very clear that when it goes over to the Senate, that they're going to follow court-rule rules. They're going to introduce evidence. They're going to call witnesses, and there's going to be cross-examination.
I hope so.
It's not. Well, it's certainly not going to be the circuits that it was in the House. I mean, in the House, it was more like something that would happen in the basement in Spain in the 1500s.
I don't know that I would quite characterize it as that. The House is a more rambunctious group. The Senate is supposed to be more.
Left out the thumb screws, but just the same. I mean, the thing that sets our country apart from the rest of the world is due process, and that was missing in the House.
I disagree with you. I agree with you that something that sets us apart is due process. I cannot agree with you that was missing in the House. Not with all these hearings, not with the Republicans having equal time to question, not with the Republicans getting to indicate which witnesses they would like to be called. I cannot agree with you.
Well, when it goes over to the Senate, they're going to have both sides will have the opportunity to call witnesses, and both sides will have the opportunity to cross-examine.
Correct.
And they'll also be able to say, objection, Your Honor, that's hearsay. And once they do that, it's pretty much over because everything up until now has been pretty much secondhand.
Rich, but there are 27 exceptions to the hearsay rule in the Federal Rules of Evidence. So don't think that just because some news broadcaster has labeled something as hearsay, which it may very well be, that it doesn't fall within one of the exceptions to the hearsay rule. That's what trial lawyers have to know all the time. We don't have to just know the hearsay rule. We've got to know the exceptions because they're critical.
Well, I'll be interested to see when it goes to the Senate exactly how they define a whistleblower and how they define a leaker. This whistleblower, he's no more the person who is the anonymous whistleblower is a leaker because he did not get it firsthand. Is that right or wrong? Am I missing something?
Well, you're wrong because he's followed the whistleblower statute to a letter. So what he did was perfectly consistent with law.
He did not follow the rules to the letter. He was supposed to, if I read the whistleblower law right, he's supposed to go, I believe, to the Inspector General, and then he went to Adam Schiff's staff. He made an inquiry
as to what he should do. He was told to make the complaint to the Inspector General, which is what he did. Not everybody knows exactly all the procedures about everything. People call me and I tell them what to do, and they don't even need me. But you're right. He did contact Adam Schiff's staff. Absolutely, you're right. And that could be painted any one of a number of ways. But unless we just don't believe anybody, the staff basically instructed him that the proper procedure was to contact the Inspector General, which is what he did, or she, or it.
Well, gentlemen, I hate to jump in, Rod. I really wanted to ask you another question, but I have to walk into a doctor's office.
All right, and we know you're going to wait an hour and a half now.
Enjoy your wait.
Take care. Thank you. I think we have Jeff online too.
I think so.
Jeff, how you doing?
Hopefully he's still there. Hey, Jeff.
Good.
We got a couple minutes, so let's do a hit and run here.
All right, real fast. I'm an independent voter that you talk about.
Okay.
I'm a guy that sits in the middle. I'm on the left. I'm not on the right. I try to stay with what I think is right. All right. Number one, Democrats are in deep doo-doo. No doubt in my mind they're in deep doo-doo. There's so much to this with the FISA abuse, and it's going to pop up. It's whatever, they've attempted to do here, it's just not panning out. It's not panning out. I'm an average, normal American citizen. I'm 65 years old. I'm somewhat college educated. I'm not trying to say, that I'm a brilliant scientist, but in the layman's terms, they take away all the attorney stuff. That's what
Then let me ask you a question, a real serious question. If you're concerned with the FISA stuff and that it may show that the initial warrants were not properly issued, what about, will that take away from you in terms of your analysis all the underlying things that have now proven to be true that are unrelated to Russia, have to do with a completely different incident, Ukraine?
Well, here's what I sort of feel. The most absurd something that you would think somebody would never, ever, ever do becomes reality. That's when you say to yourself, man, I don't disbelieve anything anymore. There'd be a day I would say there's no way in this world I would think somebody from the FBI would get involved.
Okay. So, but what does that do now to you? How do you analyze the evidence on Ukraine? And given that we have 2 minutes, do you believe the evidence shows wrongdoing or not?
Hello.
Are you there, Jeff?
Rich? I think a cell died. Yeah.
All right. Well, I guess we won't get that answer from this independent voter. We'll probably get it in 2020 at the ballot box, and we won't know which one was Rich's, but maybe he'll call us back another week. Anyway, so we only have a couple minutes. I will say this: I like talking about the substantive legal stuff that I do.
Yeah, you bring up some great stuff.
But honestly, to me, the purpose of this show is not. I mean, I'll answer all your questions, but there's only so many times I can discuss small claims court or sexual harassment, or I bring them up back periodically. I am a student of politics as well, and politics is ingrained in the law. The Constitution's a legal document, and it's one of the things that I litigate. And not all the aspects of the Constitution, but when we're dealing with discrimination and civil rights, we're dealing with constitutional law. So I bring up these political things because they integrate with the legal, and I find them interesting. I hope you do too. It looks like I'm just about out of time. That music is playing, where they're trying to drag me off with a hook. So I hope you all have a wonderful weekend. I hope you have a great week. And I'll be back next Friday after Thanksgiving. Hopefully you're all not so stuffed that you don't listen. Have a great day. Have a great weekend. This is Stuart Address for Ask a Lawyer.
You've been listening to Ask a Lawyer right here on WPSL, Port St. Lucie. WPSL.com worldwide on Alexa and Google Home.